In today's episode, we're going to be talking about fatal mistakes companies make in collective bargaining. My name is Bob Chiravelli. I'm a practicing labor lawyer and founder of Strategic Labor, a firm that advises organizations on their workplace issues and people-related challenges. I've devoted my professional life to understanding the workplace, the challenges of working people, the organizations that employ them and represent them, and the government institutions that control and regulate them. Collective bargaining is not a beginner activity. It's not for people who don't do well with conflict. Like other complex negotiations, it takes education, experience, and a good deal of practice. It is not a 6-month rotational assignment. It is a practice area that has to be developed over years. Whether you're bargaining in the areas of complex litigation, mergers and acquisitions, environmental disputes, urban planning, or in this case, collective bargaining, mistakes in preparation and your negotiating approach and the post-negotiations follow-up can prove very costly and lead to fatal flaws or flaws in reaching an agreement. The first fatal flaw is poor preparation. Without good prep, everything else in the collective bargaining process will be worse. If there is one major mistake I've seen over and over again, it is management waits too long to start preparing for negotiations. Even when management does attempt to allocate enough time for prep, what they find is that time flies by way too quickly. Surely, managers must realize developing a negotiating strategy, like any other business strategy, takes time. Not starting soon enough in your preparation is a costly and fatal mistake. So what's the rule? Start at least 6 months in advance of your first negotiating date to prepare for the actual negotiations. Next, costing your labor agreement is essential, but in almost every case where I'm called in, there has been very little or no costing done, or maybe inadequate costing. We use a very detailed costing protocol for labor costs, particularly the cost of labor agreements, because it is different from other cost accounting. For the labor negotiator, it provides a baseline for understanding and a way to analyze the cost of evolving proposals. Applying this to a broader business perspective, it can provide insights to labor inefficiencies and eventually the effectiveness of future changes in the use of labor. Although we like to divide collective bargaining into economic and non-economic subjects, they are in reality all economic and have a financial impact. However, how can the management negotiating team know what the financial consequences will be without a detailed understanding of labor costs? The chief spokesman in particular must be a master of the costing, because any costing mistake in negotiations will ultimately be his or her failure. So what's the rule? Use a costing protocol for understanding labor costs and the cost of the labor agreement. Next, select your team wisely. You do not need a large team, but you need to ensure that your team has knowledge of the company's operations and policies, a good understanding of the labor agreement, and the rights and responsibilities of the parties. They must also have strong interpersonal skills, not the least of which is the ability to listen actively. In addition, the team will need creativity, consider, and develop options. They need to have a reputation for trust, especially with the other side. They need to have a reputation for honesty and credibility, and enough authority to make the decisions. The teams at the bargaining table need to have all of these. Others will be in support roles, not necessarily at the negotiating table. Once the team is established, they must commit to staying completely engaged throughout the negotiations. So what's the rule? Choose a team whose collective wisdom is greater than the sum of the parts. You could have the best negotiators in the world, but without a strategy and established strategic goals, the negotiations will be lost. Labor agreements and the relationships that underpin them are complex, and it can be overwhelming to decide on a strategic set of goals. Ultimately, the negotiators need to decide their bargaining initiatives and the related priorities. Here are the 3 central questions that need to be decided in establishing a strategic set of goals. Number 1, what to change. Number 2, what to change to. And number 3, how to cause the change. Clear thinking makes for clear strategy. Strategy or chaos, it's your choice. So what's the rule? Develop strategic goals that are tightly aligned with the corporate strategy with effective ways to execute. Next, develop 3 or 4 important factors against which to assess company and union proposals and counterproposals. Make this a central and continuing assessment. It will also assist the negotiating team in determining the relative importance of its proposals prior to the start of negotiations. These key factors should be tightly aligned with your strategy and also serve as a unifying theme in staying on track during the negotiations. So what's the rule? Prior to drafting your proposals, develop 3 or 4 factors against which to assess proposals and counterproposals. Next, not understanding settlement ranges for achieving your goals is a serious mistake. Often, a negotiator will have a small window of opportunity to recognize a valuable proposal or counterproposal. By understanding the settlement range on the whole range of topics, the negotiator will be able to maximize the outcome by securing an agreement before the window of opportunity closes. In addition, it is also a good way to understand, issue by issue, if and when an impasse occurs, and if it is truly an issue for which the company is willing to risk a strike. So what's the rule? Understand what the minimum acceptable and most acceptable agreements are to define your settlement range. Next, make a clear and objective assessment of your true bargaining power. It is not impossible to shift the balance of bargaining power, but it can be very difficult. Without bargaining power, or even worse, a miscalculation on bargaining power, the negotiations is doomed. The rule: understand your power relative to the unions, and where possible, shift it. Next, not planning for a negotiations failure is a horrible planning event and can prove fatal to your company's existence. Even though strikes are a relatively infrequent occurrence, companies should prepare for the occurrence of one in the same way and for the same reasons that a company prepares for any disaster. They should do so in a labor negotiations. Consider risk management or the cost of insurance. The rule: prepare a strike contingency plan. I hope you've learned something about the fatal flaws in negotiations. Thank you very much, and I'll see you in the next episode.